Hello, ladies and gentlemen. Welcome to our webinar series 2020. Today's topic is topic number 7 out of 10, Design Law Basics. Our speakers today are my colleague Andrea Breyer and myself. I'm LexDellmeier. Not attending the webinar today is our colleague Caroline. For those of you who do not know us, LexDellmeier, we are a small IP boutique firm with 9 professionals who are specialized in the fields of trademarks, designs, copyrights, and licensing. So the question is, what are we going to talk about today? So let's take a look at today's agenda. The first topic will be an introduction, economic value of a design. Second topic will be what is a design from a legal point of view, how to acquire a design right, possibilities and recommendations for design applications, so tips and tricks, strategic considerations, what benefits do designs have, a conclusion and outlook on the next webinars, and any Q's and A's you may have. So let's start off with what is the economic value of a design. First of all, bringing the design into context of the non-technical intellectual property, we have done this overview here. As you can see, we have trademarks, designs, copyrights, company names, title rights, and domains. As you can see, the circles have overlaps, meaning that these intellectual property rights are not to be seen separately, but in certain areas there are overlaps, either regarding prerequisites or what kind of protection the intellectual property right grants. We will see that at the end of the webinar because we're going to focus on trademark versus designs and designs versus copyrights, so you actually understand the differences between especially these core non-technical IP rights. So, what is the value of a design right? Very difficult question, not easy to answer because there are not a lot of studies around. So the answer in essence is, and we've taken a sample from the automobile and industry. So here, from the automotive industry, you can see that the value of design rights for a company is approximately between 10 and 20% and is steadily increasing. As there are not a lot of studies, for this reason, this study from the automotive industry is a little bit older, but as you can see, BMW, Daimler, VW, and Honda, they all put the design value into their books. Okay, so the next question is, what is a design from a legal point of view? And I'm going to hand over the presentation to Andrea, who will go into detail.
Thank you, Alex, for handing over. Also from my side, a warm welcome to everybody who found his or her way to our webinar today. And I hope you will enjoy it. So what's a design from a legal point of view? In our everyday lives, we encounter designs everywhere. It's basically in every product. Every product has a design. On this slide, you can see just a few examples of more or less known product shapes that are also registered as designs. For instance, the green round circle over here is a logo of the Apple icon where is. Then here you have a brush from a very known German manufacturer of kitchen utensils that always have or often have some figurative element which makes them kind of special. next to the brush some kind of packaging that looks like a jacket, kind of nice. A Longchamp handbag, Nike shoes. Here you can see the whole shoe, and over here to the right, just the sole of another shoe, but also from Nike. Then we have the Intel butterfly that Intel uses for showing where its Intel Inside technology is used. And down to the right, or lower right corner, at the lower right corner is the Airbnb logo, the Belotero, which is probably also known to a lot of you. So all of these logos, products, icons have a shape, and we consider, or we call them designs. But from a legal point of view, that's not sufficient. While also legally, design is basically defined by the outer visible shape of a product, its lines and contours, its colors or color gradients, like when a dark blue slightly becomes a lighter blue. Contrast is something that you can see in this shoe to the left very good, because at least 3 to 4 different kinds of gray shades are used. The surface structure, which also can be seen clearly at the shoe, where you have these, well,
applications.
Yeah, nipple things, yeah, applications. And the round circles that are just distinguishing the shoe from other forms and designs that are out on the market. Then surface structure is an important point when we talk about design. Materials that are used for products, material properties, like if a certain product feels very smooth when you touch it, or very harsh, and of course ornaments. But those are only the outer visible features of a product. That's not sufficient from a legal point of view to call something a design, a legal design. Instead, you also need novelty and individual character of the product, of the product design. And only if those two prerequisites are given, then you can enforce a design right. So when are novelty and individual character given? A design is novel when there's no earlier identical design. However, very minor differences in designs are not sufficient to consider the younger design novel. So if the younger design has only slight differences to what's already known in the market, it will not be considered novel. Yes?
I'll jump in here just as an example for everybody. So there was a rather famous case decided in Sweden for Mercedes, so the E-Class. As you know, most car manufacturers bring out a new model, usually very novel from a design point of view. However, after maybe 2 or 3 years, they do a sort of facelifting. So just minor aspects of the original design are changed. And then if you reapply for the design, the facelifting, this is not a new design. It is not sufficient because the features are not much different from the original design. This just as an example, so to see at minor differences do not fulfill novelty.
novelty in this case means worldwide novelty. So any similar, or not similar, any identical design that's been published anywhere in the world is a problem if you want to file the identical design now in Germany and EU, what we're specialized in. But it's more or less the same for all other jurisdictions as well. So general rule, worldwide novelty required. Harmful are in particular all written publications, like technical journals, trade magazines, product flyers, catalogs, patent applications, sales. If you already put your product out on sale, that's a problem. Exhibitions and trade fairs where you show your product. You should not do that if you do not want to harm your novelty or the novelty of your product design. However, there are a few exceptions. This is country specific, but for instance, in Germany and the EU, the designer is granted a grace period of 12 months ahead of the design application date, in which he or she can already publish the design, show it on trade fairs, for instance, at trade fairs, without harming novelty. That period is granted by the law to give you the possibility to see, is it worth putting more money and effort into a specific design, or does the market reject it and the product doesn't fly, as we say. So in Germany, EU, 12-month grace period. In other countries, that's differently. South Korea, for instance, only grants 6 months, and in China, there's no grace period at all. So that's always something to be looked at when you talk about novelty, or when you try to assess the novelty of a specific design. What's also not harming novelty is if you disclose your design under non-disclosure agreements. For instance, when you talk about licensing out your design. Besides the novelty of a design, we said that it also needs to have individual character. Now, the individual character depends on the forms, shapes, and designs that already exist in the market at the application or priority date of the new design. That is, the individual character depends on the degree of freedom that the designer of the new design had when creating it. A small scope for a designer to create something exists if there's already a large number of existing designs in the same product category in the market, which only show small differences. However, in these cases where there's only a small scope for the designer, it is said that the consumers and the market will recognize these small differences. Thus, even those small differences are already sufficient to constitute individual character of a new design.
Let me give you an example here at this point in time again. Individual character is a very difficult, there's a very difficult legal assessment behind it. But to give you an example, if you are talking about handbags and shoes in the fashion industry, that means there is a very, very large variety and large density of products, meaning that already small differences by a designer may actually create a new design. So it always depends on the category of product you're looking at. If you look at, for example, pretty wild example, space shuttles. Not a lot of space shuttles exist, meaning that already if it is rectangular, has rectangular wings, round wings, or whatever, just differences, you know, there's the variety is very, very different. So it means, in essence, it means the more dense the product category is, the less differences the designer, or it doesn't have to be more creative in order, or has to be more creative in order to have a difference, and the other way around. So in essence, it's a very gray zone from a legal point of view, and there's a lot of case law out there.
Would you like to continue?
Yes, I would. Thank you. All right. What is the point here? As with all intellectual property rights, we want to point out searching is a very big issue. All of you who attended one of our first webinars, Trademark Basics, there we went into detail. We said, you know, if you apply for a trademark, you really have to search if there are no prior similar, identical, or similar trademarks, because otherwise you have, similar here to the designs, a risk of collision. So the proprietor of an earlier design can block your market entry or stop you. You can receive a warning letter or an injunction or a cancellation action. It can have serious consequences, namely the destruction of marketing materials and products. It damages your image. The other party, the prior holder of the design, can request damages and, of course, request information and accountings for your sales and everything. So you have to reveal all this information. So it is important to see and to search if earlier designs exist. However, I may warn you, it is not as simple as it is with trademarks. So when do you search? Similar to trademarks, you search before you apply for the design, meaning that forms, shapes, designs beforehand. Of course, it is best to also, after you use the design or put it on the market, to do a second quick search. Why? Because when you search beforehand, the databases are not real time. There is, what you do with a search, you do a risk reduction. The outcome of the search is not, there is no risk. So what do you search? Design databases, internet machines or search machines, product directories. In addition, as you know, certain products have special catalogs or online catalogs. So the lighting industry is very special, handbag industry. So there's a lot of industries who have their own directories where you can look into. Then, of course, all relevant publications accessible to the relevant public in the EU. So what are the free searchable databases? We've put some examples and links here. So the German Patent and Trademark Office, the EU IPO is rather good, WIPO, and as another example, the US PTO. So you can search here. However, I may warn you, design searching is something very special. It is a profession by itself, searching designs. So our recommendation would be to actually engage an expert in that field, and there's a couple of them out there here in Germany. We as a firm use Schutzmarkendienst. It's a very old searching company, and the reason why we use this company is because they have expert in this company for various product categories who have been dealing with designs for 15 to 25 years. So they actually know what they're looking at, what they have to look for, they're trained, and then they send the designs out. And then, of course, as a lawyer, you have to assess according to the law, are they similar or not? But that's just a tip from our side. You can do some preliminary searches, but of course doing in-depth searches is better to do that through an outside specialized company. They are rather expensive. As you may know, database costs, Thomson CompuMark or Wolters Kluwer, for some basic similarity trademark searches in the field of word marks is maybe around 200 or 300 euros. Legal assessment maybe around 1,000 or 1,500 euros. Designs, it is different. The database costs are much higher, so you have to budget around 500 to 1,000, maybe even 1,500 euros for professional database costs, plus the legal review, which is higher and in more detail, is maybe around between 2,000 and 4,000 euros. So design searching is much larger. As a little tip on the side, of course, the designers who design something are usually experts in their product category. So what we tell clients is, if you are a designer, please take a look and actually record or docket other designs or anything that you see with a date. So that may become important at a later stage if there is a legal battle. So somebody who designs something should collect information on other designs in order to have that potentially at hand if they do not want to spend the money for a professional search. So that brings us to the next point. How do you get a design right? Andrea?
Thanks, Alex. As you know, design rights, just like trademarks, patents, are not protected worldwide per se, but are only valid where you register the rights. So, worldwide protection possible? No. Instead, you have to file for national design applications in the individual countries, whichever you want. In Germany, it would be the German Patent and Trademark Office that's responsible for German design applications. If you would rather like to protect your design in all of the European Union, you may obtain a registered community design by applying for it at the European Union Intellectual Property Office in Alicante. Currently, the community design is valid for all 27 EU member states, plus the United Kingdom until the end of the year. Then everything will slightly change. But at the moment, it's still 27 plus UK. And then there's the possibility to combine different national design applications by filing only one application with the World Intellectual Property Organization in Geneva as an international design registration, which is usually recommended when there are, well, let's say more than 2 countries where you would like to protect your design in. So how about German designs? How do I obtain a German design? You file an application with the German Patent and Trademark Office, and the office then checks formal requirements of the application. Have you given the name of the applicant? Have you, of course, paid your fees? Have you given a Locarno Classification, meaning have you told the office for which product category you would like to protect your, not protect your design, but in which product category your design falls, your product. Or if they also check if your design is at all eligible for design registration. That's not the case for mere ideas. What the office does not check, unfortunately, let me say, is novelty and individual character. Earlier, Alex mentioned that in particular, the individual character, and how to define it, and how to define the scope of protection that your design has. It's not examined by the office. The office does not tell you, yes, your design, your application is novel and it contains individual character. This is unfortunately left to infringement proceedings or cancellation actions. However, formal application requirements, if they are met and the office does not have any objection, your design application will get registered. In Germany, that at the moment takes quite long, about 8 to 10 months. But the office is, well, they are aware of the problem and they're working on reducing the time frame. And once the design is registered, it will get published either immediately or deferred if you ask for a deferred publication. What does that mean, deferred publication? It means that only basic details of your application, like the applicant's name, the Locarno class, things like that, will be published on the register, but nobody will see what your design actually looks like, the shape of your product. That can be nice for what industries like the automobile or automotive industry, where you don't want your competitors to know what your new car looks like, but at the same time, you want to make sure to have an early date of protection and also bar others to some extent from using your design. However, during the time of deferred publication, where the shape of your design has not been published yet, you don't enjoy full protection of a design registration. Your design is only protected against copying, meaning that you have to prove that the other party that you claim is infringing your design right has come up with its own design knowing of your design. As you can imagine, this is very hard to prove, and yeah, in a lot of cases, it's just impossible. Nevertheless, the law gives that possibility that even though your design has not been published, you could still go against a third party. Once registered, the German design is valid for a maximum period of 25 years. With the original application fee, the first 5 years are covered, and afterwards you have to pay renewal fees every 5 years, up to the maximum of 25. Formal requirements in Germany. You, of course, have to file reproductions of your design. You have to show the public what your design looks like and what exactly you would like protection for. You can file up to 10 reproductions of the product, either in color or in black and white. It doesn't matter, at least not for the office. You can file photographies, drawings, or CAD drawings. Everything's allowed in Germany. The important issue is that the claimed object of protection must be clearly identifiable. So we always recommend to file perspective views of the design. Then it's very important to use neutral backgrounds. no other goods. So sometimes you will find pictures on the register where somebody has just photographed, let's say its desk, only wants protection for some product in the middle of the desk, but then there's the telephone to the side and all other kinds of things. No, Office doesn't like that. Use a neutral background. Also, use dark and solid lines to outline the object of protection. If you use dashed lines, that shows that parts that are dashed are not claimed, that you don't claim protection for those parts. So that's a difference that should always be taken into account.
Yeah, there will be some examples.
Yes,
so this is a little bit of a theoretical outline of the guidelines, but you will see later on we're bringing some samples so you will actually see how and who does it properly.
Yeah, exactly. It's possible to combine up to 100 individual designs in the same application. That's a so-called multiple design application, but it's not one design registration in the end, but it will be as many design registrations as you file designs in the same application. Like if you file 4 individual designs in one application, you will have 4 registrations in the end. Then you have to indicate what kind of product your design is used for. You do that by using the Locarno classification. It's like the NHTSA classification for trademarks, where different countries have found a consensus on putting products, different goods into an order to make design applications more, or the outcome of design applications more reliable on a worldwide basis. And then in Germany, there's some optional declarations that you can make. You can claim the priority of an earlier design. The priority period for designs is 6 months. So if you would like to file a German design application, let's say today, 1st July, you can use the application date, the priority date of another design application that you filed, for instance, in France on the 15th of March. That's possible. 6 months before the application date. After, or if these 6 months have passed already, like if the French design has been filed in October last year, you could still file the German design application and it would also get registered. However, it would lack novelty because the French design had already been published before and might not be worth a lot. You could discuss grace period maybe, but depends on the individual cases. Then another optional declaration is that you can say which designer designed your product, and you can file a description of your design, which sometimes you see it, but it's not used very often in Germany. But if your design contains some points that you would like to focus attention also of the consumers and competitors to, then you file a description to show that, emphasize that. Just briefly, a couple of examples of design applications. The design, or the picture to the left is how you should not do it. The chair is just not recognizable in front of the black background, and the features of the design cannot be clearly determined. So put it on neutral background, like the white one to the right, and you're fine. The same is with numbering, lettering, or measurements. The office doesn't like that, and you will probably get an objection. So don't use those. And on this slide, you see an example of a multiple design application with 4 designs. These 4 chairs all look different. They either have armchairs or they don't. They are black or they are red, but they're not identical. So you can combine design applications for all of these 4 chairs in the same application, one multiple design application, but you will receive 4 registration numbers, and each of the 4 designs has to be renewed separately. We've already heard about the Locarno classification. Now for the chairs that we saw earlier, we put the class 6 classification of Locarno on this slide just to show you how it's built up. Like class 6 covers furnishing in general, but then it also contains subclasses like 601, which has seats. It covers all kinds of seats. So our chairs would be classified in subclass 601. But furniture also covers, for instance, clothes hangers, mattresses, curtains, carpets, blankets, all kinds of things. So which classification or which product category to use, you always have to be careful. We now have like the same overview that we just gave you for Germany. We have now put in slides for the registered community design and for the international registration as well. However, we have highlighted the differences yellow because the main prerequisites and requirements are the same. In particular, in Europe, design law, just as trademark law, is largely harmonized. So there are really no differences, except that the EU IPO will register your design a lot faster than the German Patent and Trademark Office. With the EU IPO, you can have your registration already after about 5 to 8 days, which compared to the 8 to 10 months that we talked about earlier is, it's incredible. It's an incredible difference. And it might come in quite handy if you very fast need to get a design right. For instance, because you need to enforce it on a trade fair, exhibition, or similar. The protection period is also 25 years, and renewal fees have to be paid every 5 years. Instead of 10 reproductions per product, the EU IPO only allows 7. However, you can file 3 more to show a more complete picture of your product, but you have to define which 7 reproductions are the ones that are actually defining the scope of protection. And here, unlike Germany, where only a maximum of 100 individual designs can be combined in a multiple design application, the registered community design allows for an unlimited number of designs, as long as they all fall into the same Locarno class. One important thing to know is that with the in the European Union, we don't only have registered community designs, but also unregistered community designs. If you publish your product, if you bring it into the market, if you show it in trade fairs, if you publish articles about it in the press, you automatically receive an unregistered community design if the design is novel and has individual character. But if it does have that, you automatically receive the unregistered community design. It's protected for 3 years, EU-wide, and currently still in the UK as well. The protection, however, is only against copying, just like we heard it for the deferred publication, which is a lot less than you get with a registered community design. But nevertheless, if you don't have any registered rights, in particular no registered design rights, but you see somebody who's copying your design, it's always worth looking at the first publication date of your own product to assess whether or not you are still within the 3-year period to go against the infringer or the potential infringer for infringement of your unregistered community design. It's always something to be taken into account. International registrations. With international registrations, the most important issue is that you have to remember, since not just you don't file for design application or for design protection in one country, but in several countries. All these countries have their own individual requirements of when something is considered novel, when it has individual character, but even the kind of drawings that they would like to see, the reproductions of the design. This is all very country specific. So when you think about filing an international design registration, take a look at the different countries that you would like protection in and see what the requirements are and already adjust your international application. You will most likely, like if you have, let's say, Germany, which allows basically everything, like drawings, cut drawings, or photographs. And then you have, so you combine all these different pictures in one application, and then you have the UK that only allows either line drawings or cut drawings. You will most likely receive an objection from individual countries that you designate in your application. However, if you, at the time you file the international registration, already have all these different pictures that you might need in individual countries in the application, it makes it easier to split or delete individual things. The international design registration will get registered with WIPO after about 3 to 5 months, but then the national offices of the designated countries will further examine your application, and that can take up to 18 months. this I will just briefly point out again. Country-specific requirements is the most important issue to be aware of when filing an international registration. And some countries might require that you name the designers, that you file a description, or that you put like design claims worded in the way like a patent claim is drawn. So you have to be aware of these individual country-specific requirements ahead of time, because it's sometimes like the designer names or addresses, current addresses, not from half a year ago, might be hard to obtain. Examples for the cost of a design application. This slide shows a single design application covering only one design, electronic filing with immediate publication, and 7 reproductions of the design. The official fee, as you can see in Germany, is very low. It's only 60 euro. With the registered community design, the cost is 350 euro. And for an international design registration designating only the EU, so in the end, having the same scope of protection like a registered community design, you pay 550 euro, 200 euro more. That's something that should be taken into account when you come up with your filing strategy. I don't know, Alex, would you like to add something to that?
Yeah, that's an important issue. So what strategies you're going to use, and that's going to be something we're going to do in the next webinar, Design Law Advanced. As you can see, there are some differences. The German design is very slow in the registration, the EU design very quick. The international registration is an in-between. Sometimes, depending on what countries you want to designate, it may make sense to go nationally and actually file a national design. I usually say the US, China, they're not so simple. Their national design laws are different. The US requests or requires a claim, a design patent claim. Then China actually, they do substantive examination, meaning that they actually examine novelty and individual character, similar to a patent, which is not done here. So that is something, there are strategic considerations, which direction you go. And it really depends if you're going international to really have your countries that you want to do, and then sit down with either in-house counsel or external counsel. First of all, you know, depending on the country specifics to decide, or also calculate the costs and objections and quickness. So there's a lot of strategic considerations here.
In another slide, we put together the official cost for a multiple design application with 12 designs. Again, electronic filing, immediate publication, and 7 reproductions per design. As you can see, in Germany, the cost doesn't increase very much, from 60 to 72 euro, but you get 11 more designs. That's quite cheap. The registered community design goes up from 350 to slightly over 2,000 euros, a little more. And the international design registration designating only the EU is almost 600 euro more expensive than if you filed directly with the EU IPO. Well, it depends on the strategy that you want to go, but if you only intend to file for design protection in the EU, no other countries, it doesn't make sense to go the international way. That's how you acquire a design right. Possibilities and recommendations for design applications will now be given by Alex.
Okay, let's continue. So we want to give you some recommendations here, and then we're going to show some pictures in order to support what we've summarized here. First of all, try to use line drawings instead of CAD drawings or photographs. The reproductions should be in black and white or gray shades, not colored ones, because you have a wider protection. So meaning that, very simple, to put it in a nutshell for a design protection is what you see is what you get. So meaning that if you have an infringement case and you're sitting before a judge, he actually looks at the design. Now, but if you have protection and you put color in your design application, it could be that the color limits you. If somebody else has a product in a different color, it could be that you don't have protection if you have it in color. It really depends on the case at hand, but that's why we say usually use the line drawings, and black and white or gray shades. Use a neutral background. We saw that with the chairs before. Then, of course, use dark solid lines, use dotted lines for parts which are not intended to determine the scope of protection. You'll see that in our next slides. Do not use lettering. And most importantly, please, do not put the trademark into your design application. These are separate IP rights. You have a trademark, which is a separate right, and your design, which is the look of the product. You can later, when you market or sell the product, of course, put the trademark onto the product, but please do not put it in the design application. It could limit your application because your trademark is in there. And then 3D products, you usually have one perspective view and ideally 6 further views, which are top, bottom, left, right, back, front. So that's how the 6 views come together. So let's take a look at a product done by Nike, the sneaker we saw at the very beginning of the slides. This is design protection of the whole product here on the right-hand side in the big picture. You see the overall perspective view of the product, and then you see the individual 6 views, like I said, front, back, left, right, top, bottom. The next example is something which is important from a strategic point of view. You cannot just protect the design per se, but also partial designs. So a part of a product. And this, for example, when you compare it to the picture we saw before, this is only the top of the shoe. Now, why does Nike do this? Because it could be that Nike combines the top of the shoe with a different bottom or sole of a shoe, so they can mix and match parts of shoes. This is also important, as we mentioned before, the issue of facelifting in the car industry. If you only protect the overall product and there are specific parts of the product which are used again, then you need to have separate protection. Maybe we'll move on to the next one. So this, for example, is a Nike shoe sole, which you can see here. There are the different views. It's very specific in its protection. And the next picture, Andrea. So this is the same picture, but it has less details. You don't know what the infringer is potentially going to do. So therefore, some applicants file a variety, for example, as seen before, with more details or less details. So this is from a strategic point of view. As a little tip from my side, currently the best design application companies, at least this is my personal opinion, are Nike and Apple. If you want to see how companies properly apply and register designs, I would advise to maybe look at a few designs Nike applies for, or Apple applies for. It's really good to see they have a great strategy behind their whole design application process, and they also apply around the world. So this next example is here, and maybe you can use the mouse to maybe show it a little bit. You see here, those are the full lines. That means that is the protection that is claimed for actually. And there's dotted lines. That means the whole shoe outside. Protection is not claimed for the shoe, but actually for these ornamental elements, these dots, and let's say this wave application. So in that format, meaning that they have partial protection for this part, which they could apply to another shoe. So somebody who comes up on the market and has a shoe, and for example Adidas, and decides to use the design here or these design elements, it could be that that is an infringement. Again, you have to take a look at the whole product in conjunction. Is this design element, this partial product, is it new, is it novel, and does it have individual character? But again, in the application process, the offices do not examine this, and for this reason, the design applications are very low. There are very low costs. All right, some further strategic considerations. Andrea?
Yes. As Alexandra mentioned earlier, designs, trademarks, copyrights, it all somehow overlaps, and you can't draw strict lines between them. So there are a few differences, like trademarks are used to indicate the origin of a product, whereas the design protects the product itself. Trademarks are only protected for the goods and services that you claim protection for in your application. A design generally is not protected for a specific product category only. You have to mention, remember Locarno Classification, you have to mention in which products or which category of products your design is incorporated. But that does, at least officially, not influence the scope of protection of your design. It might be, it might come in if you have to define the relevant public for your design and how it's looked at by the public, how it's understood, but that's a different issue. A trademark enjoys generally unlimited protection as long as it's renewed every 10 years, renewed and used. A design can only be protected up to a maximum of 25 years and has to be renewed every 5 years until then. Trademarks enjoy an official examination of absolute grounds of refusal. Designs, there's only a slight examination, as we heard earlier, but in particular, novelty, or rather a lack of novelty, if we talk about grounds for refusal, lack of novelty and lack of individual character are not examined. A trademark application process up to registration takes about 2 to 6 months. And design applications, at least in the EU, are far more, far faster. We heard that you can obtain a design right after 5 to 8 days. And in Germany, it takes longer, about 6 to 10 months. The cost for a trademark in Germany is about 1,150 euro for a mark in one class. And with the EU IPO, it costs about 1,800 euro for an EU trademark in one class. That includes the official fee as well as attorney fees. A design is a little cheaper. A German design costs only about 760 euro, again, including official fee and attorney fee. And a registered community design will cost you about 1,000 euro, but that's for single design applications. So when deciding either to file a trademark or a design, all these points have to be taken into account. There's no either or. You can file a trademark and a design in parallel, or sometimes after design protection runs out after 25 years, companies might decide to then follow up with a trademark. That's not always automatically granted, but it's generally possible. So the term of protection and also the kind of use. If you don't use your design to identify or indicate the origin of your good, but only like as an application on t-shirts or cups or something like that, then you don't need a trademark because you will not be able to show genuine use afterwards. Design law also protects logos. Locarno Classification class 32 covers graphic symbols and logos, surface patterns, and ornamentation. And we see 3 different examples here. Alex, would you like to explain them?
Okay, all right, we have 3 here, and this is something very unique, and this is which makes the overlap between trademark law and design law a bit more clear, hopefully. So as you can see here, anti-age, especially anti-age expert, you will not get a trademark for this, or likely not get a trademark, because potentially anti-age is something that you cannot monopolize. This may be different because there is a BIOX, there is a name up there. But in general, if you are unsure if you can get trademark protection, maybe it is worth thinking about at least getting some kind of logo or design protection. This may be necessary, especially if you do licensing deals or talk to somebody, so you actually have something in place, because this logo may not be eligible for copyright protection. So you won't have anything. So the design protection via the graphic symbols may be the only possibility to do this. Then we have here 2 interesting logos on the right-hand side. This was the first one, the Intel butterfly that we had seen at the beginning of the presentation. So here it's quite interesting from a strategic point of view. Of course, there is trademark protection on these logos too. So what Intel had did at that point in time, these are rather old logos here from 2003, is that they did one version without any writing inside, because what is usual, an infringer usually comes and writes something else inside. And that's why I was talking to you before, when you generally apply for a design, you don't put your trademark inside. On the right-hand side, you will see they put Intel inside and Centrino. But also as a fallback position, also did the neutral version with nothing inside. So there is a concept and a strategy behind filing these 2. And of course, they were also filed in parallel as trademarks. Now, as stated before, the prerequisites are different. And also, for example, the protection length is different. Why did they apply for graphic symbols in class 32? Well, They brought the product onto the market, and if you fear that infringers are going to copy very fast and come onto the market and put the brand onto packaging and boxes, you need to have a registered right. And as we saw before, EU designs are registered very quickly within 5 or 8 days. So in this case, it may make sense, depending on your product or your graphic symbols, it may make sense to go this route and to have like a sort of, it's not a double protection because trademarks do not have to be novel. And trademarks can be renewed and have an unlimited amount of protection. But just so you know, so you have an overview that this is something, this is a specialty that not a lot of systems around the world has. So Germany and the EU has a special thing that they sort of snuck a little bit of trademark protection more or less into the design protection. So recommendation. If you have doubts about the registrability of your logo as a trademark, for example, absolute grounds of refusal, anti-age, original, origin, or things like that, but there is some kind of stylization around it, it may be worth thinking about getting a design protection for that. How strong it is, we do not know at the very beginning. You will see in the long run. Or if you need to obtain protection really fast, for example, as I said, when you have a registered rights, you can record your registered rights with customs authorities, and they can actually stop merchandise where the mark or the design, here the graphic symbol, is on the boxes and on the packaging. So you will have quite a bit of leverage there. Or if you do not want to obtain protection for specific goods, for example, this here, the graphic symbol for the butterfly, that would mean that Intel also has protection not just for computers, but also for t-shirts, merchandising issues. So class 32 graphic symbols in essence covers all classes. And a nice thing too is that with design protection, you know that at some point of time you have to prove use of your trademark. Various countries have different regimes. In Germany, and EU, usually 5 years after application registration or the end of an opposition, meaning that with a design, you never have to prove use. So it's also a nice issue. So let's move on.
Move on to design and copyright. With designs and copyrights, they overlap. If you have a design that's novel and has individual character, there's usually some kind of copyright also to the same design. Copyrights, or at least if it falls into the categories of copyrights, because copyright protects original works of authorship, including literary, dramatic, musical, and artistic works. Designs protect the external visible features of products. Automatic protection is granted to a copyright, so you don't register it anywhere. You get it automatically with finishing up your work. Once your work is done and you don't have any more changes to it. And it's granted up to 70 years after the death of the author, which is a lot more than the 25 years for which a design registration can be valid at the most. Unfortunately, because the copyright is not registered anywhere, in case you would like to enforce it against a third party, it'll be your turn to prove existence and scope of protection of the copyright. That's made a little easier with designs as they are registered. So at least the mere existence, and in particular a dated existence, is easier to prove. As we said, yes.
Andrea, just a quick interruption. This is something very specific regarding Germany and the EU, we don't have a copyright office. This is different in other countries around the world. For example, the United States has a US Copyright Office. So anybody can actually record and apply for a copyright in the US. And there is a special convention, it's called the Berne Convention, and I'm not sure, it's over 200 countries that are a member. So it is possible, and the copyright registration fee at the US Copyright Office is not very expensive. I think currently $55 per copyright. So that's why I just have to point out here, the copyright, what we're talking about here, copyright and design, is an overview and a comparing according to German and EU laws. But again, there is something out there, especially the US, I believe India, there's a couple of countries that actually have copyright offices.
So the copyright, since we in Germany do not register it, there's no cost involved with obtaining the right. Designs, as we said earlier, in Germany, a single design costs about 760 euro, and at the EYPO about 1,000. That's including official fee and attorney fee. And that's what I wanted to say regarding copyrights and designs.
Okay, so we already hit this over 60-minute mark, so I'm going to try and wrap it up quickly. So what are the benefits of a design? The practical advantages are, first of all, you have an exclusive right to a specific design that you apply for, and you can prohibit third parties from using the identical or very similar design that has a similar or overall impression. And it can have a significant contribution to your overall company value. So let me briefly conclude. A design is, of course, a really interesting intellectual property right. It was not very known or used as much. The whole design became very public and very famous because of the famous infringement cases going on around the world between Samsung and Apple. So it is an IP right that you really have to understand. It is not simple, and it's not it shouldn't be applied for or not for, it's not for every industry. You really have to look at it. It's easy to obtain, but you have to be very accurate in the planning. So you also need to have a long breath because it is very simple in the sense and very cheap to apply for, but you don't know which scope of protection you have in the end, because that is actually examined or ruled upon in an infringement case. And also for this reason, in order to assess if you really have a design that is novel and has individual character, also for this reason, you do a search upfront. Yes, and it can be a high share in your company value overall. So what's coming up? We have 3 more webinars coming up this year. We're going to do a short summer break, and we'll be back on October 7th. We're going to have Trademark Law Advanced on Wednesday, October 7th. It's going to be in German. Then we're going to have in German Design Law Advanced. So that's coming up on November 25th. And for all English speakers attending today, our last English webinar will be held on December 9th. And it's going to be about legal changes and then the trademark and design law as of January 1st, 2021. And the focus here is going to be the UK exiting the EU trademark and design laws. So the Brexit has taken place, but it has not taken place with respect to EU mark and EU designs. So that's why we put this webinar at the very end of the year. There are certain uncertainties. Parliament has not decided yet what is going to happen. There is a route, there is an idea, there is a vision. But for this reason, we have put this webinar. So before the end of the year and coming up on January 1st, you will actually know what you will have to take into consideration. The UK is exiting, meaning that the UK will disappear out of your EU and trademark and your EU design. So right now, just to give you a little outlook, it seems to be the concept will be that you will, if somebody has a registered EU trademark or registered EU design, that it will fall apart in the end as of January 1st. You will then have an EU mark with the 27 member states and a separate national UK right, so a design or trademark. But this is not for sure yet. So please do sign up, take a look at the events. We would very much like to have you. Let me go over any questions. You're welcome to use the chat function or use the microphone. I don't see any questions, so let's skip to the last slide. Thank you first of all for attending, and on our last slide you will actually see our contact details. If you have a specific question, please do feel free to call Andrea or me here at the office or send us an email. We will try to help you and answer your question. Again, thank you everyone for attending this afternoon, and well, hope to see you soon to one of our next webinars. Take care, all the best to you.